We thank you so much for watching Law School Made Easy. At Law School Made Easy 256, we thank you for the subscription, sharing, and liking our videos. Thank you so much. So today, I want to look at the offense of rape. That what is rape? What do we mean when we say rape? Now, as lawyers, there are principles. As learning counsel, there are principles that you must be rotating in your head. That if we are dealing with criminal law, the burden lies on prosecution to prove beyond reasonable doubt. Now we are saying, what are some of the elements that prosecution has to prove for the offense of murder to stand? For court to conclude and say that, yes, Walter, you are guilty of the offense of rape. What are they supposed to prove? That is what we call the ingredient, and sometimes some people call them the elements. Even when you're dealing with murder, you're dealing with theft, a robbery, and those other very many offenses, the most important is what are some of the elements that you must prove for the offense of rape to stand. Note, when you fail to prove certain aspects of rape, then the accused will be acquitted. So we must appreciate what are the elements that have been described in section 110 of the Penal Code. Number one, we must appreciate that the section provides that any person, so your first ingredient is any person. What does it mean? It means that any person can be male or female, can rape. Previously, people used to think that rape is only for men. It is men who rape. But the act is telling you any person, male or female, that any person who has unlawful carnal knowledge. What do we mean by? Now, the second ingredient would be unlawful. That you are having unlawful carnal knowledge with the other person. That is the second ingredient, unlawful. That it is any person having unlawful carnal knowledge. Now, carnal knowledge to mean penetration. That you're unlawfully penetrating. Now, those are the first three ingredients. We're looking at any person having unlawful carnal knowledge without the consent of the other person. That you are having unlawful carnal knowledge. You want to call them sexual intercourse. You have penetrated, and now without the consent of the other person. Then the fourth element comes and says, without the consent. That if you want this rape to stand, there should be no consent. If somebody refuses to have sex with you and you forcefully do it without her accepting, then you are committing an offense called rape. So we are saying any person having unlawful carnal knowledge without consent of the other person. So as you prove each of these ingredients, you must attach a case. For example, any person can be male or female. That is the case. You say unlawful. The act should be unlawful. So that unlawful act, you also give a case. And then you are discussing what we call the carnal knowledge without the consent of the other person. There is no consent. The act goes ahead and says that sometimes there would be consent, But if that consent is obtained by threat, that yes, you have had the consent, that she has accepted, but it was due to threat, intimidation, she's in fear of imminent danger to her life, or false misrepresentation of the act. What do we mean? We can pause it with that we are saying for rape to stand, there must be no consent. However, on certain instances, the consent might be there. But if that consent is obtained by threats, intimidation, that you put this person in fear of imminent danger to their life, then you have committed the offense of rape, even when there was consent. Or false misrepresentation of the act. You lie to them that this is not sex that we are going to have. You misrepresent the act. Okay, so those are some of the ingredients. And then the act goes further and says, for cases of a married woman, you impersonate their husband. If I impersonate the husband of any other woman and I have unlawful canon knowledge or canon knowledge with them, then I have committed the offense of rape, because I have pretended to be what I am not. I have impersonated the other person without the woman knowing. So that way you have committed the offense of rape. Now, when we are discussing the offense of rape, the most important is every ingredient we attach a case. On every ingredient, you are expected to attach a case. So we are saying that rape to stand, there must be any person, male or female, to me, having unlawful. The act must be unlawful. Canon knowledge, the penetration, canon knowledge, without the consent of the other party, without consent being another big ingredient. And then also, sometimes consent is obtained, but is obtained by by threat, by intimidation, by fear of losing life, and then also misrepresenting the act, lying that what we are doing is actually not sex, but in more so you are actually committing that. Then also we go ahead and say that for a case of a married woman, this is what the act says. For a case of a married woman, when you impersonate their husband, then you have committed the offense of rape. The offense of rape, if proved very well, if all those ingredients are proved, then that means that you will suffer death. But if it is attempted rape, in section 112, attempted rape, it means that you will suffer life imprisonment. That is how hard the punishments for rape are. So there are very many cases that I want to urge students to go and read. Uganda versus Livingstone, Sewanya and Livingstone, one of the leading cases. It has almost all the ingredients for both defilement and rape. All the ingredients are in that case. The case of Tabalo, Uganda versus Tabalo, is still going on. There are so many cases. I urge you to read those cases about rape, but I appreciate the fact that you must prove ingredient by ingredient for that offense to be able to succeed. So we thank you so much for watching Law School Made Easy at Law School Made Easy 256. Thank you so much. Stay blessed, share, like our videos. Thank you.